The family actually won the case in a 9-0 unanimous ruling.
Law enforcement can be held accountable for wrongful home raids.
Imagine waking up at 4 in the morning to the sound of your own front door exploding inward. Imagine a grenade going off inside your living room, the walls flashing white, your 7-year-old son screaming from the next room, and armed men dragging you and your partner out of a closet at gunpoint while you're still half dressed. Now imagine that. After all of it, after the terror, after the destroyed door, after the trauma that follows a child for the rest of his life, the government looks at you and says one thing: wrong house, but you cannot sue us. That is not a hypothetical. That happened in a quiet suburb outside Atlanta. And the family at the center of it took that fight all the way to the United States Supreme Court, where 9 justices, every single one of them, ruled against the federal government's position in a 9-0 unanimous decision.
The family here is telling the 11th Circuit that's re-reviewing their case that this new decision further proves why the FBI should not escape accountability for raiding the wrong house.
And here's the part almost nobody is talking about. That unanimous ruling did not end the case. It restarted it. And what is happening right now in the federal appeals court below the Supreme Court could decide whether any American in this country has a real remedy when federal agents kick down the wrong door. Before we get into it, if this is the kind of constitutional breakdown you want to keep seeing, make sure you're subscribed with notifications turned on, because these rulings move fast and most of them never make the news at all. To understand what is happening now, you have to understand exactly what happened on October 18, 2017. An FBI SWAT team was preparing to execute search and arrest warrants at a suspected gang hideout in the Atlanta area. The warrant listed a specific address, a specific street, a specific house. The agent leading that operation entered that address into a personal GPS device, and that device routed the team to a different street entirely. The correct target was a short distance away. The house they actually arrived at belonged to Curtrina Martin, her partner Hilliard Toi Cliatt, and Martin's 7-year-old son. The street sign was there, the house number was visible on the mailbox. None of that stopped what came next. A 6-member SWAT team breached the front door, detonated a flashbang grenade inside the home, and moved through the house with weapons drawn. Martin and Cliatt, believing they were experiencing a violent home invasion, hid in a bedroom closet. Agents pulled them out. Cliatt was thrown to the floor and handcuffed. Martin was held at gunpoint and could not get to her son, who was screaming for his mother in another room and could not understand what was happening or why. The mistake was discovered inside the house. While agents were moving through the property, one of them noticed mail sitting out with an address printed on it, and that address did not match the warrant. That was the moment it collapsed. The agents released the family, told them they would return to explain, left the home, and went and executed the raid at the correct address a short distance away. The family was left standing in a house with a shattered door, grenade damage, and a 7-year-old who had just watched armed men point rifles at his mother. Martin has since described the aftermath in terms that have nothing to do with money. She stopped coaching track because the starting pistol sounded too much like the flashbang. That is the kind of injury the law is supposed to have an answer for. So the family sued. They did not sue under some exotic theory. They sued under the Federal Tort Claims Act, a law Congress passed in 1946 for exactly this purpose, to strip away the ancient rule that the government simply cannot be held responsible for the harm it causes. And in 1974, after a wave of botched federal drug raids, Congress amended that statute specifically to cover claims like assault, battery, and false imprisonment by federal law enforcement officers. That amendment exists in the statute books because wrong house raids happened, and Congress decided victims should have a remedy. The family's claims included assault and battery, false imprisonment, emotional distress, and property damage. On paper, this is the exact scenario the law was written for. The government's answer was immunity. It pointed to a carve-out inside the same statute known as the discretionary function exception, which shields the government from lawsuits based on an official's exercise of judgment or choice, particularly where that judgment involves policy considerations. The federal government's position was that everything the agents did, how they prepared for the warrant, how they confirmed the address, how they approached the property, involved judgment calls, and judgment calls are protected. The district court agreed and threw the case out in 2022. The 11th Circuit affirmed, and that appeals court went further, adopting a theory that the Constitution's Supremacy Clause gave the federal government an additional shield whenever an officer's conduct had some connection to furthering federal policy. Under that framework, the family had no remedy at all. and courts were told not to second-guess honest mistakes. That is the ruling the Supreme Court took up. And on June 12, 2025, the court vacated it unanimously in an opinion written by Justice Gorsuch. The decision did two significant things. First, it held that the law enforcement provision Congress added in 1974 overrides only the intentional tort exception, not every other exception in the statute, which means the discretionary function question still has to be answered rather than skipped. Second, and this is the part with real teeth, the court held that the Supremacy Clause does not give the United States a defense in these lawsuits at all. That entire shield invented below was removed. The court then sent the case back down and specifically instructed the appeals court to conduct a careful re-examination. Because the justices said the questions surrounding whether that exception could ever foreclose a suit like this one deserved a real answer from the court below first. Two justices wrote separately to underscore something notable. In their view, there is reason to think the discretionary function exception may not apply to these claims at all. That concurrence also pointed out that the Supreme Court had not squarely addressed the scope of this exception in roughly 3 decades, despite years of lower courts splitting over it. So the case went back to the 11th Circuit, and that is where it sits right now. The core question on remand is deceptively simple to state and enormously consequential to answer. Where exactly is the line between a protected policy decision and ordinary negligence? Nobody in this dispute claims that law enforcement officers do not exercise discretion. Of course they do. Officers choose tactics, timing, entry methods, and staffing. The real fight is over what happens after the discretion is exercised. If an operation is planned with judgment and then executed badly, does the protection attached to the planning stretch forward and cover the botched execution too? Because if it does, then almost any error inside a federal operation becomes untouchable, and the statute Congress wrote in 1946 and expanded in 1974 becomes close to meaningless in practice. The family's argument has focused hard on that distinction between deciding and doing. Their position is that choosing to conduct a raid is discretion, but confirming that you are standing in front of the correct house is not a policy judgment at all. There is no policy anywhere in the federal government that weighs the costs and benefits of raiding an innocent family. Justice Gorsuch pressed almost exactly that point from the bench during argument, asking incredulously whether any policy tells agents not to break down the wrong door and traumatize the occupants. The family has also leaned on the way courts in other circuits have handled the same problem, arguing that the 11th Circuit has historically read this exception more broadly than nearly anyone else, and that reading is precisely what the Supreme Court just disturbed. The government's counter is that the two things cannot be pulled apart. Its position is that address verification, route planning, and target confirmation were all part of one continuous operational judgment, and that once you start slicing an operation into isolated mistakes, courts end up second-guessing tactical law enforcement decisions from the safety of a courtroom years later. The government warns that this would chill federal operations and expose agents to litigation over split-second calls made in the dark. That argument is not frivolous, and it is the reason this case is genuinely close rather than obvious, even after a 9-0 loss at the Supreme Court. Reportedly, that unanimous decision was drafted deliberately narrowly, which leaves the appeals court real room to maneuver, and that is why the stakes here run far past one family in Georgia. Whatever the 11th Circuit decides becomes binding law across Georgia, Florida, and Alabama, and it lands in the middle of an open split among the federal circuits over how far this exception reaches. If the appeals court rules that the exception still bars these claims, the practical outcome is that the family wins at the Supreme Court and still loses, and the immunity that was rejected at the top gets rebuilt on a different foundation underneath. If it rules the other way and holds that negligent execution of an operation is not shielded, simply because the planning involved judgment, then the door opens for wronghouse raid victims across the country, and the pressure on the Supreme Court to finally resolve the split gets significantly heavier. Either result is a strong candidate to end up back in front of the justices, and this time on the question they explicitly declined to answer the first time. There is one more layer worth noting. The Supreme Court also directed that if any claims survive, the appeals court has to evaluate liability under Georgia state law, because the statute measures the government's responsibility against what a private person would owe in the same state. That sounds technical, but it matters, because it means the government cannot simply invoke federal power as a universal answer. It has to defend the conduct on the same terms anyone else would. So that is where this stands. An innocent family, a door destroyed, a grenade in a living room, a child who will carry it, a unanimous Supreme Court decision stripping away one shield, and a federal appeals court now deciding whether the remaining shield still covers everything anyway. The nation's highest court told the government it does not get to hide behind the Supremacy Clause. What it did not decide is whether the government gets to hide behind discretion. That answer is coming. Let me know what you think down in the comments. Should the federal government be held financially accountable when its agents raid the wrong house? Or is there a real risk in letting courts second-guess operational decisions after the fact? And as always, thank you for the support, because this nation was built by armed scholars and it will be maintained by armed scholars.